Thank you. Where does this need to go, Mr. Cook, this transcript?
Well, it's a good question. I think probably it might be convenient to put it somewhere in volume 3 with the other.
Shall we put it with the actual report?
Yes, and that's not a. The problem is that Mr. Hayward Crouch's report is in several places in the bundle, but you could put it behind the.
So there's one here at 11, tab 11.
Yes, you could put it in perhaps page 198A.
Okay.
And just briefly, I mean, the court may have already had a chance to glance at it, but the relevant passage starts from internal page 79 on where my learned friend says, just to pick you up on your point of paragraph 3.6,
yeah,
which is where he's examining him about the 21,000. And by the way, just cantering through, he says it appears likely, and he basically says that he can only rely on what's in the documents that the court has already seen.
Yeah.
And my learned friend at the bottom of internal page 80, it was top of internal page 80, if I suggest to you that all payments were from out of the account from January 2011 onwards were for the purpose of GBRK's business rather than GBR's business, is that something you can confirm, or is your answer that you just don't know? My answer would be I would not confirm anything of the sort. And he goes on basically to say that he and Mr. Hall are both in a difficult position, and that you'd need a ton of more documents to firm up the position, which simply aren't available. And then the deputy judge starts to ask Mr. Hayward Crouch about a slightly different topic, but I've included that just so that you can see that it goes off in another direction.
Yes, thank you.
So I was before we break for lunch, I was coming on to ground F, which concerns the award of equitable compensation.
So in your skeleton argument?
Yes. Yes, that's dealt with. That's dealt with first because the way that the judge dealt with this, and it starts at page 55 of bundle 1.
Thank you.
Now, Mr. Davies' complaint in relation to this ground is that the judge was wrong to award equitable compensation measured by reference to the value of GBRK as at the 18th of October 2011. And before discussing the proper approach to equitable compensation, it's important to note at the outset that Mr. Davies doesn't appeal the judge's conclusion that GBR wouldn't have been able to trade at all beyond the 11th of October. October 2011. So sort of standing back on this ground from a big picture, what Mr. Davies is seeking is not really compensation at all, but overcompensation, and he's seeking to have GBR placed in a better position than it would have been had Mr. Monks complied with his duties. And I sort of pick up by way of a note as a sort of further answer to my Lady Justice Macur's question about, as it were, the can't allow frauds to get away with the benefit. Well, of course, Mr. Davies had an option to elect for an account of profits against Mr. Monks, but he chose equitable compensation. And of course, that fork in the road, obviously, account of profits against a fiduciary, which I mentioned earlier today, is one where it is an answer to say, as it were, that the company couldn't have taken advantage, or the principal couldn't have taken advantage of the opportunity. So, if one is seeking to disgorge a gain, as it were, and on this hypothesis, the gain made by somebody against whom findings of dishonesty have been made, then the beneficiary has a remedy available.
Thank you.
But we're not in that world. We're in the world of equitable compensation. And I'm going to start this by taking the court through the correct approach to that doctrine by reference to the leading cases. And then I'm going to explain why the arguments my learned friend makes are wrong. So to start off, I'm going to take the court to the decision of the Supreme Court in AIB and Redler, which I think the court will have hopefully read. It was on our essential reading list, and that's in Authorities Bundle 3, tab 46. And my learned friend has already introduced what this case was about. It was a case about the misapplication of, as it were, existing trust property. Specifically, it was the payment away of monies that were held on trust by a firm of solicitors in breach of trust. And just going inside the judgment through to paragraph 36, this is the judgment of Lord Toulson, and it's at page 1781. We can pick up the reasoning here. I should say, by way of context, the analysis of Lord Brown Wilkinson about which they're speaking is Lord Brown Wilkinson and Target Holdings. So, apologies for context, perhaps one should go back to 1778. One sees there's a section which discusses the decision in Target Holdings. And it's fair to say that there's been some criticism, or there's been some academic criticism about Target Holdings. And what the court is considering here is effectively whether it represents the law as far as compensation or equitable compensation. And so just moving back then to page 1781, I just wanted to pick things up at paragraph 36. And it says, to return to Lord Brown Wilkinson's analysis, argument B was the rationale of the judgments of the majority of the Court of Appeal. In rejecting it, Lord Brown Wilkinson cited the judgment of McLachlan J. in Canson Enterprises and Broughton Co., and in particular the following passage. And Lady Justice McLachlan, Mrs. Justice McLachlan said in that case, in summary, compensation is an equitable monetary remedy, which is available when an equitable remedies of restitution and account are not appropriate. By analogy with restitution, it attempts to restore the plaintiff what has been lost as a result of the breach, i.e. the plaintiff's loss of opportunity. The plaintiff's actual loss as a consequence of the breach is to be assessed with the full benefit of hindsight. Foreseeability is not a concern in assessing compensation, but it is essential that the losses made good are only those which, on a common sense view of causation, were caused by the breach. And that it's a well-known passage in that decision was cited with approval by Lord Brown Wilkinson in Target Holdings, where he said, in my view, this is good law. Equitable compensation for breach of trust is designed to achieve exactly what the word compensation suggests, to make good a loss in fact suffered by the beneficiaries, and which, using hindsight and common sense, can be seen to have been caused by the breach. So that was a key passage of Lord Brown Wilkinson, and that was approved by Lord Toulson. And then moving forward in the judgment to paragraph 64, page 1787. I just invite the court to read please 64 through to 66 over the page. And then the next passage I'd like to refer you to is over the page at 1789, and we can pick it up at paragraph 72. Lord Toulson says, there remains a question as to whether the Court of Appeal properly applied the reasoning in target holdings to the facts of the present case. It was argued on behalf of the bank that this case falls within Lord Brown Wilkinson's statement that until the underlying commercial transaction has been completed, the solicitor can be required to restore to the client account monies wrongly paid away. And Lord Toulson says this, this argument constricts too narrowly Lord Brown Wilkinson's essential reasoning, which is that monetary compensation, whether classified as restitutive or reparative, is intended to make good a loss. Just pausing there. I'm very aware that this area is replete with terminology to describe different things, and it can be quite confusing. But effectively, the distinction being drawn here is the different modes of assessing equitable compensation, which you see in the quantum judge's judgment. But I suppose the point I take from this is that it doesn't, according to Lord Toulson, it doesn't matter what mode, as it were, you're in. There's no short circuiting or getting around the requirement to prove causation. Of course, what may be treated as having been caused by, or how to show causation may differ slightly depending on how you're looking at it. But the important point here is that there's no sort of short circuiting of the causation requirement. So he goes on to say, the basic equitable principle applicable to breach of trust, as Lord Brown Wilkinson stated, is that the beneficiary is entitled to be compensated for any loss he would not have suffered but for the breach. In this case, proper performance of the obligations of which the trust formed part would have resulted in the solicitors paying to Barclays the full amount required to redeem the Barclays mortgage, and as Patton LJ said, the bank would have had security for an extra £300,000 or thereabouts of its loan. So they were examining in that case, which was a case which involved the misapplication of existing trust property, what would have happened if the solicitors had complied with their duties. That was what I was going to show you in Lord Toulson's judgment, and another reasoned judgment was given by Lord Reid. And I'm just going to take you to one part where Lord Reid discusses the FHR case, which my learned friend relies on heavily, and that's at paragraph 120 of the judgment of Lord Reid. It's on page 1800. I just invite the court to read that paragraph again.
To read 120?
Yes, please. Now, I need to unpack this a bit. First of all, my learned friend talked to you about the sort of forensic point to be made about the sequencing. And what happened in a nutshell was that it seems that AIB was heard before FHR was heard by the Supreme Court, but the judgments in the two cases came the other way round. So FHR, the judgment was handed down by the Supreme Court before, I think it was in July of 2015, whereas the, must have been 2014 even, but July of that year, whereas the AIB judgment was handed down in, I think, November. So what Lord Reid was doing was he knew obviously what the Supreme Court had said in FHR, and what he's referring to is the fact that Lord Neuberger said in that case, he referred to equitable compensation in that case. I'm getting a little bit ahead of myself, but what he was talking about in that context, he was using the phrase, I respectfully suggest, loosely. What FHR concerned was a case where the debate was about whether or not a bribe could be, a constructive trust could be imposed over a bribe that had been handled by a fiduciary. And in the alternative, the claimant had sought an account of profits effectively against the fiduciary for repayment of the bribe. So the actual debate in the Supreme Court was about whether the proprietary claim could be imposed on it. But in the alternative, they sought effectively equitable relief. But what they sought was an account of profits. But Lord Neuberger unfortunately referred to it as equitable compensation. So in my submission, FHR isn't a case about equitable compensation, as it were, capital E, capital C, although Lord Neuberger refers to it as such, and I'll make good that point when I take the court to FHR. But returning to this paragraph, what in my submission Lord Reid was saying was, well, look, notwithstanding that Lord Neuberger sort of expressed himself in those terms, that was concerning an entirely different sort of case, and it's different in the respects that I've just outlined. It was a case where, well, firstly there had been a bribe, and secondly, it was really a case which concerned, in the alternative, an account of profits. But we'll come on to look at that. So I entirely reject. I mean, my learned friend extraordinarily tried to suggest that this paragraph suggested that AIB didn't apply at all to a case where a director had acted dishonestly on the strength of this paragraph. But in my submission, that's not at all what this paragraph is saying. It's directed to essentially ensure that the reader doesn't think, reading FHR, that it's about the same thing as this case, which is equitable compensation. That submission may make a bit more sense when we come to look at FHR, but
these labels are, I mean, I find them always very confusing, not least because it's never quite clear when you're talking about compensation in the sense that a tort lawyer might talk about an award of damages as compensatory, or whether you're looking at a remedy which is really aiming to reconstitute the trust fund, which is really what the this horrible word restitutive is supposed to be getting at, is it? Or...
Yes, I mean, obviously in this particular case, it was one where there was a trust fund to begin with, there were trust assets to begin with, and the question that the court was, in a sense, it was requiring the trustee, the beneficiary wanted basically the entire lot, and the court said you can't have that because you wouldn't have had it even if the duties had been complied with, and that's what equitable compensation is concerned with, whereas obviously an account of profits is different.
Yes, I understand that.
But I mean, the labelling I accept is sometimes not entirely clear. What also sees in the cases which we'll look at, there's sometimes a distinction drawn between a custodial breach of duty and a non-custodial breach of duty. With the custodial breach of duty being a situation where you misapply existing trust assets, and then the non-custodial breach of duty being effectively the archetypal example is a breach of your duty of loyalty, where you prefer your own interest to that of the principal, and that gives rise to, on some interpretation of the authority, it's slightly different considerations. But in my submission, that where we've arrived at on AIB is that the counterfactual, or examining what would have happened but for the breach of duty is the inquiry in all cases. So just to take you forward then to 134, and that's page 1804, paragraph 134. So, following that approach, which I've discussed more fully above, the model of equitable compensation, where trust property has been misapplied, is to require the trustee to restore the fund to the position it would have been in if the trustee had performed his obligation. So, the submission I've just made. If the trust has come to an end, the trustee can be ordered to compensate the beneficiary directly. In that situation, the compensation is assessed on the same basis, since it is equivalent in substance to distribution of the trust fund. If the trust fund has been diminished as a result of some other breach of trust, the same approach ordinarily applies, mutatis mutandis. And then he goes on to say the measure of compensation should normally be addressed at the date of trial with the benefit of hindsight. The foreseeability of loss is generally irrelevant, but the loss must be caused by the breach of trust in the sense that it must flow directly from it. Losses resulting from unreasonable behaviour on the part of the claimant will be adjudged to flow from that behaviour and not from the breach. So you can have situations where it's not available to a claimant, to a defendant, to say, well, as a result of me having done something else, you'd have lost the property anyway. The requirement that loss should flow directly from the breach is also the key to determining whether causation has been interrupted by the acts of third parties. And he goes on to make a point about that. So, as I said, AIB was a case where the funds which constituted part of the trust fund were misapplied. And again, to try and keep my terminology consistent, at least in my submissions, I'll call that a custodial breach of duty or a custodial breach of trust case. In other words, it was a case which concerned pre-existing trust property. And that can be contrasted in my submission with a case such as the present, which doesn't concern the misapplication of existing trust assets. And that can be called, for shorthand, a non-custodial breach of trust case. And as I've already said, the important point to note for now is that AIB stands as authority for the proposition that in all cases of equitable compensation, whether classified as reparative or substitutive, the monetary remedy for the equitable compensation seeks to require the trustee to put the trust fund in the position that it would have been in had the trustee performed as opposed to breached their duties. And I've already drawn the distinction between the approach there and the approach for an account of profits. Again, the measure of that is measured by the gain of the fiduciary and not by reference to the loss sustained by the trust fund.
So in the case where the interest has gone down in value, you would have compensation to put the trust back into the position that it would have been, but for the misapplication that caused the loss. But otherwise, you say it's still not the gain made by the fiduciary.
Quite. I mean, I'm getting slightly ahead, but part of my observation on my learner friend's submissions is that the remedy that or what he says the court should have ordered is basically like an account of profits. I mean, he's effectively saying that there's no difference between the two. And in my submission, that's just wrong on the authorities. There's a clear difference between the two. And you don't get around the requirement to prove causation in any kind of equitable compensation case.
So if it's the same basis of compensation, why is there developed the reparative and substitutive terminology? Presumably it's all reparative. What it can't be is penal.
Well, I think what basically the conclusion of the Supreme Court is in AIB is that it is all
it's all the same thing.
It's all to be analysed in the same way.
Yeah.
And one gets that from Lord Toulson. There's a sentence in paragraph 54 of the judgment. If you go back to 1785. I didn't take you to this on the way through, but if you just read paragraph 54, and in particular the final part of that paragraph.
But yeah, well, yes. That's the point.
The terminological distinction is a rather old one, if you like. It's how many courts have tried to analyse all of this over the years, and with varying degrees of clarity and success. But what AIB has really drawn a line under all of that, and that's certainly the view that's taken by the editors of Snell's Equity. And I'll just show you the extract from that. It's in Authorities Bundle 4. And it's at you can put you can put 3 away for now. It's Authorities Bundle 4, page 1785, and it's tab 46.
You don't mean 46,
that can't be right. Sorry.
67 is now.
Sorry, it's 2245. I'm so sorry. It's tab 67. The lady's right. And the passage is it's 20-034.
No, No,
Sorry,
no, I've
no,
lost again.
it's 7-059.
Sorry, 7059. Is that the one?
I'm so sorry. I'm so sorry. The bit I actually wanted to take you to was at 2249. It is the final page in the tab.
Yeah.
Oh, that's 20.
20.034 through to down to the heading of accounting profits. If I just invite the court to read that paragraph. So, and just, I should say, before we leave this extract of Snell, it probably is worth just briefly taking you back to what I took you to before, 2244, page 2244. And it's the section B entitled Causation. And this is the sort of introductory section that is written before they delve into the reparative and substitutive distinction. I just invite the court to read it's 7-059. And then over the page down to the end of the first paragraph on that page. So
in a nutshell, what we gain from all of this is that the matter is now covered by AIB. So possibly all these uses of different terms are not terribly helpful.
yes.
And what we're looking for is what loss was caused by the breach.
Indeed, my lady. And the reason I go into the terminology at all is because the judge tried to distinguish, tried to put this case in a box. And this is the subject of my appellant's notice, where I say, look, there's another. The judge's order can be upheld on the alternative basis that actually it doesn't matter, that distinction doesn't matter. Look at what's said in AIB. So I'm sort of addressing that first, but insofar as the distinction does matter, I say the judge's categorisation of this as a case that didn't involve the misapplication of existing trust property is obviously correct. I was going to come on to them, but before I did, you'll have noticed in the passage that I took you to, they mentioned the case of Gwenby Valley, which is of course a case where it was a case of dishonest, a breach of fiduciary duty by a director, in breach of, I think, his he failed to disclose his interest in a transaction in which he made a lot of money and the company made a massive loss. And it might just be worth briefly looking at what was held in that case. That's in. You can put this away now. I'm finished with Snell. If you could take up Authorities Bundle 1. And it's at tab 26. Page 456, the report starts. And the facts of this case are extremely complicated, and it involves a lot of moving parts, but I've sort of tried to summarise them in the way I just have. And we're concerned here with a dishonest breach of duty. It's a non-pre-existing trust property case, because there was a failure to disclose his interest in the director's interest in the transaction. And if you could just go ahead to page 499. Again, I just invite the court to read paragraphs 46 and 47 of Lord Justice Mummery's judgment.
146 and 147.
Yes, 146, 147. So my
well, this is going again to Lord Tolson's point that it's not a penal remedy. So,
indeed, I mean, absolutely, but it's designed to do what it says on the tin, which is compensation. So one can't sort of, as it were, do better than you would have done otherwise. And it really just goes back to the same point. I suppose the reason I take the court to this particular authority is because it's an example of how these principles are at play. I mean, I anticipate one of the points one of them may have made yesterday or may yet make is, well, AIB is nothing like this case, but here we have an example of these principles, and this predates AIB, of course, but the principles are at play when you're seeking equitable compensation against any kind of defaulting fiduciary. And here is a situation where a dishonest director was able to run the argument successfully that no loss had been caused by the breach.
And the paragraph also shows, I mean, really the relevance of the counterfactual analysis, because obviously if you're seeking to compensate, you have to have, in order to quantify the loss, you normally have to work out what would have happened had it not been for the breach.
Indeed. I mean, one of the complaints I have about my own friend's case is that it's unclear exactly what the limit of liability is. It's sort of unpinned down by any kind of rational outer limit, but I'll come on to that.
Yeah.
So I've already made the point, I think, which is our respondents' notice point about causation applying to custodial and non-custodial breaches of trust. Obviously, my own friend doesn't appeal the finding that GBR wouldn't have continued to trade beyond October 2011. So again, reparative or substituted compensation, that distinction won't make any difference to the amount of the award, given what you have to look at. So in a sense, the judge didn't need to go to all that trouble to try to work out what sort of a case this was, but as it happened, my next submission is that this was in any event not a pre-existing trust property case, which is what the judge decided and which my own friend criticises. I think the way my learned friend puts the point, at least in his skeleton, is that he suggests that this is a case that should attract the substitutive compensation basis of the award, and he characterises it as a pre-existing trust property case. And the way he does that is this: he says that wherever a fiduciary receives property in breach of his duties, that property is immediately impressed with a trust in favour of the principal. And therefore, he says that it's necessary to reconstitute the trust by restoring that property or its value back to the principal. Well, in my submission, that it's a sleight of hand which incorrectly seeks to elide cases which involve the misapplication of pre-existing trust assets, which are already under the fiduciary's control, and the non-custodial breaches of duty cases. And my learned friend in particular relies on the FHR case, which he took you to yesterday. Perhaps I can take you to that. It's in Authorities Bundle 3, so you can put Authorities Bundle 1 away. Authorities Bundle 3, tab 47. Page 1847. And again, I just invite the court to read the headnote to refresh your memory of the facts of the case. It was a case about, it was against a fiduciary in respect of the receipt of a bribe, but just invite the court to read that. Then it's not necessary to read the held part of the headnote, because I'm just going to go to what Lord Neuberger says. If you go forward to page 1857, paragraph 1, this is the judgment of the court on the issue of whether a bribe or secret commission received by an agent is held by the agent on trust for his principal, or whether the principal merely has a claim for equitable compensation in a sum equal to the value of the bribe or commission. The answer to this rather technical sounding question, which has produced inconsistent judicial decisions over the past 200 years, as well as a great deal more recent academic commentary, is important in practical terms. If the bribe or commission is held on trust, the principal has a proprietary claim to it, whereas if the principal merely has a claim for equitable compensation, the claim is not proprietary. And then he goes on to make the obvious point about that being significant in the case of the agent's insolvency. And he also talks about tracing the proceeds of the proprietary claim in equity. And then moving on in his lordship's judgment to page 1859, paragraph 7. And it says here that the principal's right to seek an account undoubtedly gives him a right to equitable compensation in respect of the bribe or secret commission, which is the quantum of that bribe or commission subject to any permissible deduction in favour of the agent, e.g. for expenses incurred. This is because where an agent acquires a benefit in breach of his fiduciary duty, notes the word benefit there. In breach of the relief accorded in equity is, again, to quote Millet L.J., primarily restitutionary or restorative rather than compensatory. The agent's duty to account for the bribe or secret commission represents a personal remedy for the principal against the agent. And then he goes on to talk about the proprietary remedy. But, I mean, that case was really about whether a proprietary remedy could be imposed, and what was being discussed there was the availability of an alternative personal claim, effectively for an account of profits against the fiduciary.
And the language here is very confusing. When you were here being told we're drawing a distinction between restorative remedies and compensatory ones, whereas AIB has told us they're both subspecies of the same compensatory principle.
Well, that's if it's equitable compensation, as it were, capital E, capital C.
Well, I mean, one shouldn't have to go into these dreadful definitional. What's the word I'm looking for? Dead ends.
Yes.
If one's just trying to explain what should be a really very simple proposition, which is if you've been guilty of a breach of trust, you need to compensate for the loss caused by it.
My lord, I quite agree. I just want to.
Yes, and I'm not blaming you for this.
I want to make sure that the court.
It just does seem to make the whole process one of quite unnecessary complexity.
Yes, the reason I'm doing this is because I don't want my learned friend to sort of try to suggest that FHR was a case about equitable compensation, properly so called, and that, as it were, thereby, as you saw him try to do in relation to that paragraph of Lord Reed's judgment, distinguish AOB by reference to it, and that's really the point of going to all of this. But what I pray and aid in support of my submission about what this means is a yet further decision of the Supreme Court in a case called Aquila Advisory, and I think some of those copies may have made their way up to the bench. And again, the facts of this case are completely unimportant for the point I want to make. But it's paragraph 48 of the judgment of the court. I think it's Lord Stevens. Paragraph 48. They discuss FHR, and I just invite the court to read paragraph 48. So,
Was it just paragraph 48 you ask us to read?
yes, I mean, in a sense, the case wasn't really concerned with this point at all. The court was doing a sort of canter through various authorities about analysing how property, trust could be applied onto property, and that this is the only paragraph that discusses FHR. But I rely in particular on Lord Stevens' view that the central question, this is just below E, the central question in FHR was whether there should be a difference, so that the principal is entitled only to a personal accounting remedy and not to a constructive trust, when one was concerned with a bribe or secret commission rather than secret profits. So, I mean, it is really, on so many levels, completely different to this sort of case, and it's not concerned with the equitable compensation remedy that the court, the Supreme Court was dealing with in AIB.
So the only difference there in the compensation or the account or whatever is the order of preference.
Well,
should anything happen. So a constructive trust carries the priority.
Yes. So if the agent has become insolvent
Yes.
by the date of the cause of action, it's usually very important to establish your constructive trust over the proceeds of the bribe, because you can then follow it into the hands of others and so on.
So that's important for the point
That was
of
very
election.
important in that,
Yes.
exactly in that case. So in a sense, that was the debate. It was between personal or proprietary, and the nature of such compensation as you might otherwise be entitled to, to elect against the fiduciary was not really before the court. But in any event, what's clear is that if anything, if it's about a gain, which a bribe could fairly be characterised as, you're in the account of profits territory. It almost doesn't make sense to talk about it in terms of equitable compensation.
And is this because the bribe has such adverse commercial connotation?
No, well, not well. Clearly, the public policy factors at play in bribery cases can change the dynamic, but
Yeah.
fundamentally, the issue is that the bribe is clearly to be characterised as a gain of the fiduciary, rather than, because it's not something in a normal
Than a
commercial
lot, yes, I
It's not-
understand.
yeah.
Yeah.
So
But it is so different. The concept is so different for public policy, and as you say, it wasn't something paid from the property of the trust.
No.
It was gained as a result of the fiduciary position.
Yeah.
There was a benefit taken of that position.
yes, it was a breach of duty
Yeah.
To take the bribe.
A personal benefit
Yeah.
acquired. Yeah.
Yeah, but again, I don't, as it were, rely necessarily on the public policy's considerations inherent in bribery cases. Although I do say that that they do make this even further removed from the present case. The important point for present purposes is that FHR is not a case really about equitable compensation. Yeah. It is certainly not an authority in support of the proposition that AIB doesn't apply to the present case. So I don't see to place too much weight on the sort of the bribery aspect of it, but clearly that would have been important in that case, perhaps for resolving the question as to whether or not you get a proprietary claim. So I've sort of dealt with FHR, but I think the way my learned friend's argument is, the response is the fact that in certain circumstances the court is prepared to order that a bribe received in breach of duty is held on constructive trust for the company doesn't mean that for the purposes of assessing equitable compensation, that asset is treated as being part of the trust which the director has misapplied, thereby somehow converting the case from a non-custodial case into a custodial one. The entire argument appears wrongly to assume that there are two breaches. First, a breach of trust, and then a breach of constructive trust, that the court would otherwise impose over the bribe. And in my submission, it's simply not the way in which the court approaches equitable compensation. And in any event, no such breach of constructive trust was contended for by Mr. Davies at trial, let alone found.
I'm afraid there's still one thing that I'm finding confusing about paragraph 48 in this whole area. I mean, the issue is described as being in terms of whether there's a proprietary claim to the bribe, and the alternative is stated as being that the principal merely has a personal remedy for an account of the bribe. And that is referred to below as a personal accounting remedy or equitable compensation. I mean, really, it's accounting for a profit, isn't it?
I mean, perhaps I haven't
accounting
helped.
for a profit is in our context is being distinguished from equitable compensation, because one you elect for one or the other. You can't.
Yes.
And then here they are both being described as the same thing. I'm getting totally confused.
I'm sorry, my lord. Perhaps it hasn't really helped. I mean, Maybe further confusion is being introduced by Lord Stevens here by referring to both types of personal remedy.
Yeah. Maybe.
Clearly, in my submission, if you're trying to disgorge the gain made by a fiduciary, you're going to be seeking an account of profits.
Yeah. I mean, I can understand that. But that's not what the kind of claim we're dealing with here. That's the one thing that was not elected for, is an account of profits.
I rely heavily on that.
Yeah.
So,
because the profits can go obviously they might be far greater than any restoration of the trust property measure might have achieved. I mean, it just all depends what happened in the real world.
Yeah, we don't know.
With the misappropriated property.
Yeah. I mean, that wasn't elected for. It wasn't the subject of consideration of the contract.
Yes.
Right. Now, I'm going to move on to authorities relied on by Mr. Davies, and my own friend attacked the judge's analysis of the authorities at paragraphs 101 and 102 of the judgment. And I don't think we need to go to them. Obviously, the court can read those. That analysis stands by itself, and in the interest of time, I'll focus I've already dealt with the point that my respondent's notice point, which is that the judge didn't need to go into all of this. But insofar as he did, I say that his analysis of the authority was spot on. He was correct to categorise this as a non-custodial breach of trust, or I think as the judge used the phrase, a non-pre-existing trust assets case. Now, my learned friend in his skeleton argument referred to the decision of this court in Ord and Mackenzie against Patel. He didn't develop a case based on that authority before you orally, and unless the court would like me to address that case, in the interest of time, I wasn't proposing to. But we responded to that case in our skeleton argument.
Can you give us the relevant paragraphs? So first of all, in the appellant skeleton argument.
Yeah, so
it's paragraph 114.
It starts at page 44. It's round F, starting at page 44.
Yeah, and it's mentioned at 114.
114, page 46. Yes.
Yeah.
It's this submission that I think it's his alternative case, which is that insofar he says that questions of loss were entirely irrelevant. Obviously, I've dealt with that. Alternatively, questions of loss were relevant at all. Mr. Holland erred in noting that conversation by reference to an entirely hypothetical position that GBR would have been in if Mr. Monks had acted in accordance with his duties. And he goes on to say, while actual events may limit the amount of equitable compensation payable, dishonest fiduciary may not rely on purely hypothetical events to limit his liability. And he does that by reference to, well, among others, the cases I've taken you to, which in my submission dates support that that submission, and Ord and Mackenzie, which concerns the decision of this court where, in obiter remarks, Lord Justice David Richards discusses his interpretation of how the principle applies. But in my submission, the case isn't of any assistance to my own friend, and I wasn't proposing unless he.
Yeah, and your paragraph dealing with this.
Yeah, apologies. Yeah, that's at. It's at paragraph 15 at page 58.
Yeah.
To assist the court, just to be clear, I do rely on Ord and Mackenzie. I wasn't proposing to, I didn't take the court to it, and I wasn't proposing to. But just to be clear, I'm not abandoning.
No.
What I put in my skeleton.
No. Well, subject to my lady, my lord, I'd be content to deal with this in the in the written arguments, but
Yeah.
yes.
I mean, the short point is that was a case involving pre-existing trust property. That's the way the judge dealt with it. It was distinguished on that basis. It was also a case where the ratio of the decision, it was a case about a dishonest director extracting sums of money from his company under bogus invoices, and he argued that he wasn't liable to pay equitable compensation because he would have caused the company to make those payments in any event. And the ratio of the decision is that his defence was held not to be unsustainable in law. He was effectively relying on the AIB side of things, but there are some comments that obiter comments made by Lord Justice Richards that sort of that deal with target holdings and AIB in a way that he sort of, well, he rather sort of wonders how it would be resolved back in the court below, and one of the debates is whether the relevant hypothetical question is what would the position have been, what position would the company have been in but for Mr. Patel's appropriation of the funds, and one of the answers postulated is it would have had the money rather than that he would have caused it to be paid out. But in my submission, as well as this present case not being a custodial breach case, the judge here asked no more than the hypothetical question as to the position that GBR would have been in but for Mr. Monks' breaches of duty. And it's difficult to see how any other counterfactual could have worked. It's not a case like in Warden Mackenzie where the director was saying, well, I might in another capacity, or I might have caused loss to have been incurred in some other way. And the other thing I would say is that the decision in Warden Mackenzie has been criticised for not unequivocally following AIB and Redler. And I won't ask you to turn it up, but for your notes, there's a detailed article on this by Samuel Williams, and that's in Authorities Bundle 4, tab 69, page 2292. So that was what I was going to say about that case. In my submission, there's no reason why the principle in Redler doesn't apply to the present case. I'm also going to take you to one example of a corporate opportunity case where I think my learned friend submitted that the present case isn't like AIB and target holdings on the facts. Obviously, I accept that. Those were custodial breach cases, but what was said about the proper approach to equitable compensation in those cases applies in any event. And here, of course, there can be no real distinction between substituted performance and reparative compensation in the context of an allegedly misappropriated opportunity, as in the present case. Of course, an opportunity can't be taken from the company in the same way as a pre-existing asset can be. Likewise, an opportunity can't be restored. All that can happen is the director fails to exploit that opportunity for the benefit of the company. So in those circumstances, the only form of compensation available is to make payment to the company for the value of that opportunity, which, as I think my Lord referred to, will involve inevitably consideration as to whether it could have been exploited by the company. So in my submission, it's impossible to value an opportunity otherwise than by looking at the counterfactual, because the value of the opportunity will obviously depend on the likelihood of it being realised. And there's an example in the authorities bundle of equitable compensation being refused in a corporate opportunities case. And it was a case that predates AIB, but it's quite helpful to see how the judge analysed it from first principles, and it's the case of Lee and futurist developments. That's in Authorities Bundle 2. Tab 35, page 1208. This is a decision of His Honour Judge Hodge. In a nutshell, the facts, again, are reasonably complicated, but in a nutshell, it concerned whether equitable compensation should be awarded to compensate a company for the non-disclosure of a commission by a director and the consequent loss of opportunity to make a greater profit. The judge declined to award equitable compensation for the loss of opportunity because he concluded that the disclosure would not have changed the actions of the company. And one sees that if you take up the decision at paragraph 49, and this is on page 1231. Just invite the court just to read paragraph 49.
So this is the submission.
This is the submission.
Yeah.
And then we can skip over 50 and go to the foot of the page 51. Mr. Bartley Jones argued that. And then I just invite the court to read 51. And actually, if I just invite the court to read 52 to 54. So again, it's not a case that, as it were, applies AIB, but it's an example of how the corporate opportunity kinds of cases are dealt with in practice when it comes to equitable compensation, and one sees alive and well the inquiry in the judge's mind, which is what would have happened had the director complied with his duties. You can put the this bundle away. Stepping back really from all of this, it's unclear how Mr. Davies' analysis of equitable compensation can ever be applied in practice. My own friend doesn't say how else equitable compensation is supposed to be assessed for corporate opportunity cases. And under his approach, the director seems to have unlimited liability. If his answer to that is that the cut-off date is set by way of an equitable allowance, then he has, in my submission, no grounds to vary the order, because the judge has held twice that it was inequitable to make any award in respect of matters after mid-October 2011. Turning then to the remedy that's sought by Mr. Davies, again in my submission it's illustrative of the misunderstanding of the concept of equitable compensation. Mr. Davies is seeking equitable compensation to provide him with the value of GBRK as at the 31st of December 2015. And again, my submission is that there's simply no justification for picking that date. Firstly, it's unclear how that relates to my learned friend's submissions on substituted performance or restoring the trust. As we've already examined in the context of ground E, he talks about placing the parties in the position that they bargained for. We've already covered all of that. There was no agreement and so on. And again, I observe parenthetically that the fact that Mr. Davies is seeking a remedy which reaches the same monetary outcome as an alleged claim for an account of profits against GBRK is telling, because nothing can more graphically illustrate the wrong approach being taken to equitable compensation. How, I ask rhetorically, can you have a situation where it doesn't matter whether it's an account of profits or equitable compensation, you get to the same figure? The second point to make about Mr. Davies' desired remedy is that he appears to seek compensation for a breach of trust regarding alleged trust property comprised not only of GBRK's business held for the benefit of GBR in October 2011, but also, he says, the profits generated from the exploitation of that business. A few points to make in response to this. Neither the liability judge nor the quantum judge found that GBRK's business was held on trust for GBR as at October 2011, nor that any profits which were generated from that business were held on trust. On the contrary, I took you earlier to where the quantum judge expressly rejected the proposition that the whole of GBRK's business assets and undertaking belonged in equity to GBR in October 2011. And that finding isn't appealed, but yes, it forms the cornerstone of my learned friend's case in this regard. What the judge was doing was using or valuing GBRK as a proxy for valuing GBR as at that date. Moreover, there's no basis for the court to find that GBR's business was held on trust in any event. As a matter of law, as I mentioned earlier, Mr. Justice Lewison, as he then was, said in Ultraframe that a proprietary claim isn't available in respect of general business opportunities as opposed to specific assets. And again, I don't invite the court to turn that up, but It's at Authorities Bundle, I think, 1, tab 29 at page 626. And it's paragraph 1547. Mr. Davies failed to identify any assets actually held on trust at any point in time, or whether profits were generated from them. And thirdly, the judge's refusal to award equitable compensation against Mr. Monks by reference to payments from GBRK was correct for an additional reason, which is that claim is predicated on Mr. Monks committing some equitable wrong by causing GBRK, as opposed to GBR, to make payments to him for his benefit. And that proposition involves a further alleged but not found breach of trust, including after GBR was dissolved, and isn't a recognised or recognisable claim in equitable compensation. So, unless there were any questions from the court about ground ground F, sorry, those are my submissions.
No, thank you.
Ground G, and this concerns the appeal against the quantum judge's determination of an equitable allowance in favour of Mr. Monks. Now, my own friend's submission is that the 30k equitable allowance constituted double counting, since it didn't take into account sums which Mr. Monks in fact received from GBRK. Now, I'll make a number of points about this ground. The first is that it's common ground that the judge had a discretion to award an allowance. And so, to make the obvious point, Mr. Davies faces a high hurdle in demonstrating that it was so plainly wrong to be out with the wide ambit of reasonable disagreement. The second point is that, as my Lady Justice Asplin observed yesterday, the judge plainly didn't overlook or fail to take into account the fact that monies might have been received by Mr. Monks from GBRK. He expressly deals with that possibility. I just invite the court to take up the judgment again, just to have a look at what the judge says. It's in volume 1, tab 17, at page 309. Page 309, starting at paragraph 180. Now, he mentions the 78,000 figure, and he goes on to say this, which is important. Whilst this, of course, does not necessarily directly affect the question of whether and to what extent Mr. Monks is entitled to an allowance in respect of equitable compensation, which he is ordered to pay to GBR, it does at least show he was in fact remunerated for his efforts in the real world. He then goes on to say, at paragraph 182, at the foot of the page, on the facts here, I'm prepared to grant Mr. Monks an allowance to recognise the skill and effort which he displayed in building up the business of GBRK. However, in my judgment, it would be wrong to allow Mr. Monks anything more than $3,000 a month, which I find was contemplated by the agreement described in the handover note. And he goes on to describe the handover note in the remainder of the paragraph. And that's all I intend to allow him, £3,000 per month for 10 months. And that's how he arrives at the 30,000. So in my submission, clearly the judge was aware of all of those points, and he was right to note that the question of an equitable allowance concerned the hypothetical position of GBR and not the actual position vis-a-vis GBRK, which is a point he makes at at the top of page 310. And when he remarked that it would be wrong to allow Mr. Monks anything more than £3,000 per month, he was clearly referring to any further sums by way of equitable allowance, rather than, as Mr. Davies assumed, making a finding that the total sum that Mr. Monks should receive, both equitable allowance and in the real world, be £3,000 a month. Thirdly, in my submission, the conclusion was plainly not out with the ambit of the judge's discretion. Mr. Davies' position on this ground appears to be based on an incorrect premise, which is that the judge held that Mr. Monks had received a net benefit from GBRK over the first 10 months of its trading. The judge didn't make that finding. While he did accept Mr. Hall's conclusion that the financial record showed that Mr. Monks received payments from GBRK of £78,000, he didn't make any finding that Mr. Monks benefited to that extent. And in my submission, aside from the fact that it would require this court to make a further finding of fact on that point, which it should not, it's actually impossible for this court to determine the extent of Mr. Monks' net benefit. I make that point for several reasons. Firstly, the amount of £78,000 is for the period to December 2011. So it includes 2 months after the cut-off date of October 2011. The judge also found that for the period to February 2011, Mr. Monks' director's loan account showed a balance owed to Mr. Monks of £261,000. And one can find that in the judgment at paragraph 125. We don't need to go to it, but it's on page 289. So even if any payments were made, it appears unlikely that any net benefit accrued to Mr. Monks. And in my submission, a calculation of Mr. Monks' net benefit would additionally be complicated because of the guarantees he gave to support GBRK's borrowing. And those are dealt with at paragraph 127 of the judgment. Again, the page reference, same bundle, it's page 289. But aside from those points, and stepping back, once again, the size of the equitable allowance is a matter for the judicial discretion. Even if it were assumed that Mr. Monks had a net benefit of £78,000, and that was added to the amount of equitable compensation awarded, that would amount to a total of £108,000. And in my submission, that can't sensibly be characterised as a conclusion that no reasonable judge could have reached.
Isn't the problem really, there just appears to be an internal contradiction between what the judge says in 182 and his conclusion in 183. I mean, he says at first sight, this seems completely plain, it would be wrong to allow Mr. Monks anything more than £3,000 a month. And in the next sentence we're told that's additional to anything he might actually have got from GBRK. I mean, how do you reconcile those?
Well, I mean, but first of all, it's absolutely clear that the judge was aware of this distinction. And I think the only way to construe the judgment is to consider what the judge was actually looking at, which was the amount he was prepared to grant in excess of that. I mean, there's no other way of looking at it. I mean, he simply must have done, because otherwise, if he didn't, he wouldn't have added the words in excess of the amount, any sums. Because I think, again, if you look at paragraph 183, this sum is in addition to any sums which Mr. Monks might actually have received from GBRK in the relevant periods. What the judge is saying is, look, I don't have to, and I haven't determined what benefits Mr. Monks may have actually received from GBRK in that period. And for the reasons I've already given in my submissions, it's not something that this court can form any view on, no more than the judge could. But what he's basically saying is, well, whatever was the real situation, I'm prepared to let that rest as it was. And by reference to his rationale is by reference to the handover note. I'm certainly not. I'm going to give him 30,000, and that's what I'm going to give him by way of an equitable allowance. I mean, there's no other way of construing the judgment. I mean, the judgment must have known this. So the question really for the court is whether that exercise of discretion was out with the bounds of reasonable, the sort of reasonable bounds of the judge's discretion.
I mean, supposing we took the view there is a contradiction which the judge hasn't satisfactorily explained, I mean, that might be a reason for saying he just hasn't adequately reasoned as part of his judgment.
Well, I mean, what I've said is, I mean, the submission I've just made is about stepping back and looking at the overall conclusion as being one where you have it. At most, you're looking at something which is 108,000. I mean, that's assuming against me that you're able to, as it were, be satisfied that he received an amount of 78,000, which I say you can't be. I mean, as I said, the obvious point on that is that you can't simply. I'm going to come on to address what my learned friend said. I mean, what he says is that the outcome, what my learned friend's actually inviting the court to do on this, is not really to set aside the judge's exercise of discretion in granting an equitable allowance. It's actually to change the basis of equitable compensation altogether. What he's saying is that you need to add the 78,000 onto the equitable compensation figure and then take off 30,000. So he sort of he bags the 30,000, if you like. And so in that sense, his appeal, it's strange. What he's really inviting the court to do, and this is why the argument as framed is objectionable, is he's suggesting that this court needs to add the sum of 78,000 onto the equitable compensation. So in other words, a new finding of equitable compensation in 78,000 to which the 30,000 equitable allowance is applied. That's what he's inviting the court to do. And in my submission, that the court cannot and should not do. I mean, that would fundamentally change the basis of the assessment of equitable compensation. It would suggest that it's a sort of hybrid, because of course, as the court knows, the equitable compensation is measured by reference to the value of GBR K as at that date. But this would be to raise it by reference to this matter on which, in my submission, you simply can't safely form a conclusion.
Well, if we can't form a conclusion ourselves, but we think that the judge's reasoning doesn't stack up, I mean, another possibility could be simply to remit the matter to him for further consideration.
Well,
on the one hopes unlikely assumption that the parties couldn't reach agreement on it between themselves.
Well, my lord, I'd obviously oppose that. I mean, again, one has to really step back and look at what this court's role is. I mean, we're talking about the exercise of discretion and about, dare I say it, relatively small sums of money.
Oh, absolutely. Yes.
Is this really something that judicial resources below the judge, etc., should be getting involved back in circumstances where, as my learned friend said, and I think my Lady Justice Asplin said it's plain as a pikestaff, that the judge had considered the point and he still said, no, I'm going to grant that equitable allowance. So in my submission, it would be I certainly wouldn't encourage that kind of an approach from this court, and it really would be going into.
I quite take the point. It would seem disproportionate to make an order of that nature. On the other hand, speaking for myself, I do still have some difficulty in understanding what the judge thought he was doing.
Well, I understand the point. I've tried to explain as best I can.
Need to reflect on it, and
I mean, what I say is that, and here's where it comes in. Unless this court can, as it were, be confident that the 78,000 is a benefit, it has no business in interfering with the award of equitable compensation, which is what my learned friend's relief relies upon. I mean, what he's not saying, it seems to me, is, well, you disallow the 30,000. He's suggesting something quite different. And so, in a sense, the answer to his appeal is, well, no, the court isn't going to start making new findings of equitable compensation to increase the amount.
Yeah, it does look as though the judge made a finding that £78,000 was remuneration, doesn't it? Because he shows that it does at least show he was in fact remunerated for his efforts in the real world.
Well, I mean, what I'm focusing on here is what's said in paragraph 180, where he says, I mean, what was in Mr. Hall's report was really just Mr. Monks has received these cash amounts. That was what the judge was focusing on. And one of my points is, well, absent the court's finding that constituted a benefit in the hands of Mr. Monks, one simply can't go into that.
So in paragraph 180, the final sentences, the judge says, the receipt by him of such sums, which must be the 78,000, in my view, would have to be taken into account in the valuation of GBRKs at October 12, 2011, as it would have been a factor contributing to the financial state of GBRKs at that date. So, to an extent, an award of equitable compensation based on the value of GBRK is already taken into account certain payments made by that company to Mr. Monks. So, in that paragraph, he seems to be saying, I don't need to consider it.
Yeah, he's not making any specific finding.
No.
It's slightly strange in a sense, and this was touched upon in my learned friend's submission, because, of course, the judge hadn't valued GBRK on that basis. I mean,
No.
This is obviously the subject of the cross appeal, but he hadn't valued it on a sort of net assets basis, where it's a sort of made perhaps a direct relationship between monies that might be extracted or not. So it's sort of even more. I mean, I suppose the way I would put it is this: the judge was clearly aware of a potential impact that any of this might have had on the valuation. Clearly, in his mind, it seems that he considered that there might have been an impact. But nevertheless, he felt it was appropriate to grant an allowance. So it's not a factor which he overlooked.
So Mr. Shaw said yesterday that the judge was asked to reconsider this part of his judgment, and did so, and merely added one sentence, which we see in 183.
Yes, I'm afraid I don't have all of the paper. I mean, it may well be that he did add that. I'm not sure. He may have added other bits. I simply don't know. But what I do accept, I suppose, is that this point was flagged and by my learned friend, and it didn't cause the judge to change his mind about the conclusion that he'd reached.
No, he obviously didn't think he needed to explain. It merely says for the avoidance of doubt, rather than in explanation of the same.
No, indeed. I mean, he uses the phrase for the avoidance of doubt.
Yeah.
Rather than for the creation of yet more doubt.
Well,
Which might...
All right.
I mean,
anyway.
I've made the submissions I've made. I mean, you understand the points about the raising of equitable compensation, and strangely, my own friend isn't sort of, as it were, attacking the judge's exercise of his discretion to grant the allowance, but sort of inviting this court to do something slightly different. And in my submission, it would be quite wrong of this court to increase equitable compensation as a result. I mean, perhaps I can sum up in this way. I mean, first, the court shouldn't interfere with the judge's exercise of his discretion. He clearly knew what he was doing by making the award, and he didn't consider that there had been any inconsistency or double counting in arriving at that conclusion. I've tried to divine from the wording why he might have thought that. It may lie in the distinction between the hypothetical and the actual, the GBR versus GBRK distinction. But in any event, he knew what he was doing. And in my submission, it's not for this court to substitute its own view based on submissions and further findings that it would have to, in my submission, make, and certainly not do something as disproportionate as remit the matter for further argument, given the amount of time that this case has and judicial resources this case has taken up, especially over a sum as trivial as 30,000. So, in my those were. May I just those were going to be everything I was going to say on the final ground. I mean, it follows on slightly from what I've just said, but I mean, one observation is that really 30,000 in the context of this case, even in the context of a case like this, is fairly to be characterised as trivial. Especially in addition to...
well, it has been raised in the ground of appeal for which permission has been given to argue it, so we've got to come to a conclusion on it somehow or other. I
accept that. Unless the court has any questions, those are my submissions.
Thank you very much.
Right, so how would the court like to... I think in the timetable we talked about possibility of me opening the cross appeal. Does the court, would the court prefer us to do that, or to hear from a learned friend?
Response, Mr. Shaw.
I think something to be said with that.
Yes.
Complete
yes.
the argument on this part.
Yes, we're going to complete the argument on this part of the appeal. So we will ask Mr. Shaw to respond.
Yes. Thank you.
I will follow my learned friend's order of play. I will respond to grounds A through to F. As to ground A, which is the question of construction, that's the paragraph 272 point, as it's been called. I should be clear about the criticism I make of Mr. Holland. My primary point is not that Mr. Holland neglected to make findings of breach of duty. The criticism I make of Mr. Holland is that he considered himself constrained by paragraph 272, which prevented him from taking into account the property received by GBRK in what my learned friend and I have termed the second period, so the 22nd of May 2011 to the 18th of October 2011. So my primary position is this. I don't say it was necessary for Mr. Holland to make further findings of breach of duty. Mr. Johnson had made the necessary findings, and you'll recall that in answer to my Lady Justice Asplin, you asked me about the division of labour, my lady. Mm-hmm. And I said, well, what Mr. Johnson did was make sufficient findings to justify an account, and by that what I'm referring to there is the process described by Lord Millett in Libertarian Investments, and so that's the Chancery Master working out where the property is, and quantifying it, and determining the appropriate remedy. And my learned friend said, well, that's not what the quantum trial was about, but that's wrong. I wouldn't have been thanked by anybody, not least by my client, for asking Mr. Johnson to direct an account only after the liability trial. But it would have been perfectly within my client's rights to ask for an account, and then there would have been a hearing to determine where is the trust property, or what was its value, And after that, and only after that, I could have sought a remedy. The quantum trial involved both of those stages. It was the taking of the account and the award of a remedy. So, as I said yesterday, my submission is that on a fair reading of the liability judgment, and so I'm certainly not going to take you back through it, but if one reads the whole of the liability judgment, I ask rhetorically, is there anything, on a fair reading, is there anything in the liability judgment which remotely suggests that Mr. Holland, the quantum judge, would be prevented from looking at property received by GBRK in that second period? And of course, my learned friend says, well, yes, because there was a strict division between the liability stage and the quantum stage. And he said, first of all, if I had wanted to expand the scope of the quantum trial, I should have either asked Mr. Johnson to make further findings, or I should have appealed. Well, just to deal with the latter point first, as I said to Lady Justice Macur yesterday, there would have been nothing I could appeal. I won the argument about the terms of the order, and an appeal is an appeal against an order, not a judgment, and I got an order in general terms. As to the former point, asking Mr. Johnson to make further findings, it's worth just exploring how this would have worked, because as I understand my learned friend's case, what he says is, well, just to take one example, you have seen, both of us have shown you extracts from the report of Mr. Hayward Crouch, where Mr. Hayward Crouch undertook an analysis of GBRK's books and records, and he identified particular items of property which were received by GBRK in the second period. So the computing equipment for £8,000, vehicles, skips and bins and so forth. Now, according to my learned friend's thesis, that expert evidence would have been needed at the liability stage. And so what I would have had to say to Mr. Johnson is, please make a finding that in that period, GBRK received X number of skips, and that was a breach of duty by Mr. Monks. I mean, on my learned friend's thesis, that's what I would have had to do before I could move to the quantum stage. And I submit that that's not realistic, and that wasn't what anybody intended. The question at the liability stage was Mr. Monks in breach of duty? We were then going to move on to look at the nature and scope of look at the property received by GBRK as a result of the breaches of duty. That didn't constrain the court at the quantum stage. So notwithstanding the fact that paragraph 272 doesn't make reference, for example, to new customer contracts fulfilled by GBRK, that certainly wouldn't have prevented the court at the quantum stage from looking at those matters. I'm sure the court has my point, but it's hard to say. On my learned friend's thesis, there's not a lot would have been left to the quantum stage. All of the identification of the property taken by GBRK, the number of contracts, the vehicles and so on, all of that would have had to been dealt with at stage one. And so paragraph 272 would have been a lot longer. And it would have said, and in the second period, GBRK fulfilled X hundred, X thousand customer contracts, and that was a breach of Mr. Monk's duty of loyalty. I appreciate, of course, I know I'm not speaking to a jury, I never have, and I hope I never will, but there was a flavour during the course of my learned friend's submissions that the findings of dishonesty in this case were limited and so in some way not very important. I'm not going to take you to them, but suffice to say that Mr. Johnson applied the entirely orthodox Ivy and Genting Genting Casino principles, and it's a suggestion which my learned friend has made below. It wasn't quite repeated here, but there was a flavour of it. It was suggested that well, Mr. Monks might have been dishonest in relation to the 7 matters set out in paragraph 272, but he wasn't dishonest in relation to anything else because there was no finding. Well, I mean, just to take a step into the real world, honesty is essentially a binary thing. I mean, you either are honest or you're not. This was, in my submission, a dishonest scheme. My learned friend said you won't find any suggestion at all in the liability judgment, any words to that effect. It is true, you don't find the words dishonest scheme, but I won't ask you to go to it, but I do, for your note, please just refer to paragraph 338, where Mr. Johnson said that he found in effect, well, I won't paraphrase, why don't I read it out? I've come to the conclusion, taking the steps identified at 272, Mr. Monks was acting dishonestly. I say that essentially because in my judgment, Mr. Monks' actions in late 2010 were not inspired as an honest response to the situation he found himself in, but instead by an honest desire to take over for himself the opportunity which presented itself to trade from the Ashford site. So yes, the words dishonest scheme weren't used, but you get pretty close there. Before I move on to ground B, just to pick up a point made by Lady Justice Macur, both to me and to my learned friend. My lady, you put the point, well, did Mr. Davies lead any evidence at the quantum stage which would have enabled the court to make further findings of breach of duty? My answer to that respectfully is my client didn't have any evidence to lead because this wasn't about my client's conduct at all at that stage. There was no evidence that I could have led. So what this must amount to would be me cross-examining Mr. Monks, which is in fact what I did. And it would have been me putting to Mr. Monks, well, you took customer contracts into GBRK, didn't you? And then I would have made a submission that was a breach of duty. But the point I'm making is I don't accept, if this was my lady's point, I don't accept that there was any evidence I could have led which would have assisted the court at the quantum stage to make findings or make further findings of breach of duty.
I think that was the point. How could the judge at quantum stage have made further findings without evidence? Because he certainly couldn't go back and tweak the findings of the liability judge, could he? He couldn't say, well, you couldn't find it, but I find from what's floating around that he could have found X, Y, and Z. That was the point I was seeking to investigate.
Well, I mean, the quantum judge, he obviously had before him all of the witness statements which had been...
Yes, but you don't have 2 bites of the cherry with respect. You have, in accordance with the order that was made by the master, a liability hearing and a quantum hearing. And you certainly don't say to a different judge at quantum, well, we'd like you to go back and revisit the findings. That's for an appeal court, not for a quantum court.
Well, my lady, I certainly accept it wouldn't have been open to me to ask Mr. Holland to make inconsistent findings with those made by Mr. Johnson. I certainly accept that. But to pick up my Lord Sir Launcelot's point this morning, paragraph 272 does begin with the word including. I don't accept that that Mr. Holland was in a straitjacket, if you like, and he was unable to at the quantum stage to look at matters outside paragraph 272, provided, of course,
provided there was some evidence about those other matters. You can't just say, 7 matters have been found against Mr. Monks, and therefore, as you put in your skeleton, all steps that he took are to be regarded as dishonest. I don't actually agree with you that it's a binary question of honesty and dishonesty.
Well, you've heard what I've said about
Yes, of
that.
course.
I mean, on the facts of this case, I respectfully submit it's very difficult to see how that would work. But
Well, we have your submissions on that.
If I could turn to ground B, you've obviously heard a lot from both of us on that. I don't have a lot to, excuse me, a lot to add. But if I could just, if you've got the quantum judgment open, my learned friend made his submissions by reference to the judge's discussion of the cases. We'll pick it up at paragraph 236 onwards. And then I was going to say a few words about criterion properties, which the judge referred to at paragraph 240. And what my learned friend submitted was that the decision in criterion was consistent with his case, that knowing receipt depends on the receipt of pre-existing trust property. It's not about a knowing recipient entering into a new contract, the opportunity to do so being presented by the fiduciary. Again, I'm not going to take you to the decision, but that case is simply not on point. What that case is addressing is a very different set of circumstances. That was a case in which the fiduciary in breach of duty caused the principal itself to enter into a contract. It was concerned with a poison pill arrangement.
Sorry, I didn't hear that.
Sorry, it was concerned with a poison pill arrangement.
Right.
So an arrangement which was designed to stymie a possible takeover of the. I don't think it was a company. In fact, I think it was an LLP. But in any event, it was an improper contract, the purpose of which was to prevent the takeover of the claimant. And the question for the court was whether the contract was enforceable, and it's in that context that the Supreme Court said this has got nothing to do with knowing receipt. This is simply a question about whether this is essentially an agency question. So does the counterparty know that the director has acted in breach of duty? So this is not a case where the Supreme Court was considering the position we have here, which is the knowing recipient, GBRK, entering into contracts with a third party. Again, in the interest of time, I won't take you back to buyers. We've both my learned friend and I have referred you to that and taken you to the passages we rely on. It won't surprise you that my submission about that case is that that case doesn't say anything about property before its receipt. It was, if you like, the direct opposite of the issue that confronts this court. What I am saying is, you don't need property in order to found a claim for knowing receipt. You don't need pre-existing trust property. The critical thing is that at the moment of receipt, the new contract, whatever it is impressed with a trust. In buyers, there was no question at all. That issue simply didn't arise because in buyers, well, at least for the purposes of the Court of Appeal, there was no dispute about the fact it was pre-existing trust property. The real issue was whether following receipt, the property continued to be held on trust, and the claimant's problem, and it was held to be insuperable, was that the receipt was governed by Saudi law, and Saudi law doesn't recognise trusts. So I did have a look over the short adjournment to see whether I could work this out. Certainly, I haven't been able to determine whether these cases were referred to in argument, but certainly Cook and Deeks and Buller were not referred to they're not referred to by the Court of Appeal in the judgment. And one can see why they wouldn't really have been relevant. That it being common ground, at least for the purposes of the Court of Appeal, that there was pre-existing trust property. Again, I won't take you back to Buller. My learned friend and I have said a lot about that case. As I think as I accepted yesterday, of course I have to accept that the words knowing receipt were not used. But what I certainly don't accept is that Buller is a sort of special case concerned with unfair prejudice. The critical thing is that, as the Court of Appeal recognised, the relief which the first instance judge granted was a declaration that the recipient held the property on constructive trust, and that's not some special remedy under 994. That was a declaration based on the general law of trusts, and so. My learned friend says, well, it's a case which is really about directors' duties. It's not really about the remedy. I would submit respectively, you can't dismiss the case quite as easily as that, because as we know from the Court of Appeal judgment, the company, the recipient, was joined as a party.
Didn't you go through this just today, Mr. Shaw? Because it's supposed to be a response now, not a re-arguing of the points that you made just today.
I understand. You've heard what I've said about
Yes.
Buller. But as for Cook and Deeks, I mean, again, I'm not going to take you to it. The only point I would make is that I'd be very happy to be corrected by my learned friends. They would have done the same exercise as me. But I've tried to identify when Cook and Deeks has been relied on, and I'm not aware of any case up until the quantum judgment in this case where significance has been attached to the precise process by which the company Dominion obtained the property. In CMS Dolphin, the judge, Mr. Justice Lawrence Collins, said it didn't matter. But as I say, I'd be very happy to be corrected. But I have done some digging. I haven't found a single case where until the decision in Davies and Ford, that made a difference. My Lady Justice Macur, you explored with my learned friend under ground B the sort of point about is there a lacuna in the law, and my learned friend said no, because there's always a remedy against the fiduciary. I don't want to repeat what I've said. I will just make 2 points. Number one, an account of profit against the fiduciary will be an account of the profits which he personally has made, and he may not have made any. The second point is that in my submission, the judge's approach to both to knowing receipt and equitable compensation the approaches were too narrow. And equitable compensation on the judge's approach is all about compensation for loss. So you could easily have a situation in which the fiduciary says the principal has suffered no loss because it could never have had the property, it could never have had the business which has been diverted, and the fiduciary also says, and I haven't profited personally. So it's clear breach of duty of loyalty, but there's no effective remedy against anyone. In relation to ground C, I have said, I think, I may just have a moment. The only thing I want to say about ground C is this. My learned friend suggested that the extraction of the 21,000 from GBR's bank account is not something which I had raised. That isn't correct. This isn't a case where I've dug around in the evidence for something the judge hasn't dealt with. If I could just so we don't need to go to it now, but if I were to just give you the reference, you've got my closing submissions in bundle 3. Bundle 3, tab 9, page 103, and it's paragraphs 72 and 73 of my closing submissions at the quantum trial. There's specific reference to Mr. Hayward Crouch's table in his report. The table shows withdrawals of 21,000 from the bank account, and then I've referred to Mr. Hayward Crouch's view. It appears likely the 21,000 received was withdrawn and utilised to the benefit of GBRK. So it is something. This isn't just me opportunistically looking for something to raise which wasn't raised before the judge. It certainly was.
I think Mr. Cook's point was this was information that was available at the liability trial because disclosure had been made of those documents and nobody sought to pick it up before the Mr. Johnson, as he then was. I think that was it. I don't think he was saying that you hadn't picked it up because he showed us the cross-examination you'd made, Mr. Hayward Crouch.
I see. Sorry, maybe perhaps I missed.
I'm sorry, I hesitate to rise. I made that point, but I also, Mr. Shaw, I think hasn't quite accurately captured my submission. My submission was not that it had never been raised, but my submission was that he didn't invite the quantum judge to find that this money had been knowingly received by GBRK. That was my submission.
So we can see from the transcript, Mr. Shaw, you obviously did cross-examine upon it.
That's correct. So just to pick up the point my learned friend just made, did I ask Mr. Holland in terms to find that GBRK had knowingly received 21,000? No, but let me read out the first sentence of paragraph 73. Mr. Davies invites the court to conclude that all withdrawals from GBR's bank account from January 2011 onwards were for the benefit of GBRK's business, including in particular the withdrawals of 21,000 in the second period.
So we look at paragraph 73 for that?
Yes.
Yeah, thank you.
In relation to ground D, which is the claim in relation to the site, my learned friend said at the start of his submissions that he made the point that Mr. Monks had paid rent And so this was, to put this in context, I think this was in response to my point that Mr. Monks took the second lease as trustee, and as a result of that, GBRK was able to trade the business at least until 2016, when the freehold was acquired. And I said, well, what this means is that Mr. Monks has used property belonging in equity to GBR without paying for it. And my learned friend's response is, oh yes, well actually a price was paid, it was the rent. But of course that misses the point. It was rent paid to the landlord. It wasn't rent paid, it wasn't a sum paid to GBR for the use of its property. That's the point I'm making.
But the landlord at that stage was not GBR, was it?
No, well, the landlord has never been GBR. It was
GAL.
lady. No, it was GAL until the 23rd of June, when there was a sale to Benchmark.
That's it, Benchmark. So the rent's got to be paid to Benchmark rather than to. I'm sorry. Can you just make that point
the
again?
point I was making
please?
it was a simple one about. You'll understand. My basic complaint is that property belonging in equity to GBR has been used after the 18th of October 2011, and no price has been, no sum has been paid to reflect that use. The point I was making is that Mr. Monks took the second lease on trust for GBR, and Mr. Holland made a positive finding to that effect. There's no appeal against it. So you have property belonging in equity to GBR being the lease. So you have a trustee of the lease who uses the lease for his personal benefit. Those sums, to put it neutrally, has been paid to the beneficiary to reflect that use. So the fact that the trustee might have paid the rent is neither here nor there. I think I need to just clarify one thing. My learned friend made a point that in attacking my thesis was the case I put forward, which I say justifies a finding that GBRK acquired the freehold on trust for GBR. My learned friend made the point in the course of his oral submissions that at the time of that acquisition, so in 2016, GBR had been struck off the register and dissolved for a number of years. And so he said Mr. Monks didn't owe any duties anymore as a director, and GBRK couldn't have been a knowing recipient, knowing receipt of it being based on receipt of property in breach of duty. But the point is this, that the claim to the freehold, it's not based on a fresh breach of duty by Mr. Monks as a director, and it's not based on a fresh instance of knowing receipt by GBRK. It's based on the unappealed findings of Mr. Holland, namely that Mr. Monks took the lease as trustee and then assigned the lease to his company GRL, and Mr. Holland found GRL took as trustee too. So this is trust property, and this is Foskett and McCowan territory. This has got nothing to do with knowing receipt. This is just property stuff. If you are anything other than a bona fide purchaser of the legal estate for value without notice, you take subject to pre-existing equitable interests. So I never asserted, and I don't need to prove that Mr. Monks continued to owe duties as a director for the purposes of making good this claim. The key to it is that in 2016, you have trust property belonging to GBR. Unless you have any further questions for me on D, I'll move to ground E, which is the discretion, the point about discretion.
No, thank you very much. Thank you.
My learned friend took you under this ground to the Novoship decision, and the point he made about that case is that the court drew a distinction between the liability of a fiduciary to account for profit and the liability of an accessory. And the court said, well, if you're an accessory, you don't owe fiduciary duties, and so the rules might be different. And so to this extent, they are different. Causation is relevant. But then my learned friend, it was a sort of clever sleight of hand, as he said, well, if causation is relevant, in deciding whether or not to grant grant an account of profit against GBRK, it was Mr. Holland rightly took into account the fact that GBR would not have been able to trade beyond October 2011. But that's that is irrelevant. The causation here, the causation question is this: were the profits made by the knowing recipient caused by the receipt or not? It's got nothing to do with did the principal suffer a loss. So what what the court found in Novoship was that the profits which were being claimed were not generated as a result of dishonest assistance, but generated effectively as a result of the assistant's own efforts. So it's focusing purely on the accessory. It doesn't. So here, what you say is, were the profits generated by GBRK caused by the diversion of business? And as you know, I say the answer to that is plainly yes, because GBRK would have no business unless there'd been diversion in 2011. So Novoship doesn't stand for the proposition that you take it that the counterfactual requires consideration of whether the principal suffered a loss. My learned friend dealt with the point made by Mr. Holland, one of the reasons given by Mr. Holland for refusing an account, the point about double recovery. And what my learned friend said is that it was appropriate. It was appropriate for Mr. Holland to take into account the fact that an award of equitable compensation. He was willing to make an award of equitable compensation against Mr. Monks, and that would be a reason for withholding a remedy against the knowing recipient. Well, you've heard what I've said about the joint and several liability and the way the court avoids double recovery is at the execution stage. But this is pretty surprising if this is correct, because just forget all about this case. Just imagine, just take a different case where a claimant sues a number of defendants, say for a conspiracy, and the conspiracy is proved. And then the question is, against whom should an order be made? Well, the court doesn't investigate who's good for the money, which one of the defendants should pay up. I mean, an order is made against all the defendants. And then it's open to the claimant to pursue each of the defendants to judgment. And if it's the case that one defendant pays more than his fair share, he can bring contribution proceedings against the others. My learned friend also suggested that this would be a very complicated exercise. If an account were taken, it would be all very complicated and expensive. And he said that it would be necessary to identify the profit, the assets, the assets in respect of which the account is to be taken. So what I understood him to mean is that what the court would have to do is identify the profits referable to the knowing receipt. So, but one only has to consider this for a moment to see why that wouldn't work, because take the computing equipment, which is a great example. I mean, it is unreal to talk about the profit made on computing equipment. That's not how this works.
You did mention this yesterday.
Yeah. But the point is that you don't look at, the business wasn't operated in a granular way. There's a portfolio of assets which are used to generate an income.
You made the point yesterday, Mr. Shaw.
Turning to ground F, which is equitable compensation. I'll make this submission politely. You'll understand why I need to say that. It is FHR is obviously binding on this court. In my submission, it cannot be dismissed as readily as my learned friend invites you to. You have AIB and FHR, which were both heard by the Supreme Court and decisions handed down within very close together. Well, for good or ill, the Supreme Court in FHR has said in terms that equitable compensation is available, equal effectively to the amount of the profit made by the fiduciary, the unauthorised profit made by the fiduciary. So equitable compensation is a broad concept. My learned friend criticises me. He says, well, in Mr. Shaw's case, he effectively just treats an equitable compensation as the same as an account of profit. So what's the difference? Well, there is a difference on these facts, because if I had sought an account of profit against Mr. Monks, that would focus on Mr. Monks, on the money which Mr. Monks himself had made. And so, for example, he's received substantial remuneration. Let's say that he bought properties, he developed properties with the remuneration he received. Well, an account of profit would look to value the properties which Mr. Monks had developed with the remuneration he'd been paid, and an order would be made stripping him of his personal profits. But that's not what I'm doing. That's not what I seek here. What I'm saying is that the compensation he's required to pay is equal to the value of GBRK's business at a particular point in time, and being the 31st December 2015. So it isn't the case at all that an account of profit would give you the same answer as equitable compensation. The point about equitable compensation is, so on my case, it's about restoring trust property, and then so what is the property? Well, it's all of the assets which were diverted, and then it's a question of valuation. So it's wrong to say that on my case, an account of profit will always give you the same answer as equitable compensation. It won't. My Lady Justice Macur explored a point with my learned friend, which was whether bribes are something special, whether that's a sort of special category. My lady, the answer to that is no. I'm not going to take you back into FHR, but the Supreme Court acknowledged the public policy grounds, But it was a case. It's a case on secret profits, basically. It's not. The Supreme Court didn't say bribes are particularly pernicious, and therefore we need a special rule. It's based on. It's based on unauthorised profits made by a fiduciary.
Thank you.
My learned friend took you to the decision of His Honour Judge Hodge in Lee and Futurist. I'm not going to take you back to that, but in my submission, it doesn't really advance matters because it was accepted by the counterclaimant, I think it was, by Mr. Bartley Jones, the counterclaimant, that equitable compensation is compensatory, and what he was seeking was compensation referable to the loss of an opportunity. And what the case is all about is whether on the facts there was a loss of opportunity or not. So it doesn't help with a question for you, which is the fundamental legal question, which is equitable compensation always to compensate for loss? Finally, as to ground G, the equitable allowance, if you've got the quantum judgment open, page 309. These are not, it's paragraphs 178 and 179 that I was going to refer you to. I don't believe I took you to these yesterday, but I was really picking up my Lord Sir Launcelot's point. If one reads 178 and 179, what the judge is considering is the terms of the handover note. And so at 179, the judge says, the proposal that each of Mr. Davies, Mr. Ford and Mr. Monks would only receive £3,000 per month was clearly a matter which related directly to Mr. Monks. I cannot therefore accept that Mr. Monks was unaware of the fact that he was at least initially only to receive £3,000 per month from what was a newly incorporated company. So, and then that, I've already made submissions about 180. And then if one goes to 182, and so it is obviously the second sentence that I rely on. So it would be wrong to allow Mr. Monks anything more than £3,000 per month. Well, that is consistent with the judge's finding at 179. So I do say that there is an obvious inconsistency here. Why mention the hand? What's the relevance of the handover note at all? I asked rhetorically. If this was intended to be an additional allowance on top of what Mr. Monks already had, why make reference to Mr. Monks only being entitled to £3,000 a month? Unless the court has any further questions for me, that's my reply.
No, thank you very much indeed, Mr. Shaw. Right. So tomorrow we start with the cross appeal.
Yes, please.
We have your respective skeleton arguments in relation to that.
Yes, those are in volume 1.
Yeah. And there's also file 3, which is the...
File 3 contains the authorities I'll principally be taking the court to.
Yeah, okay.
Apologies, my lady. The Griffiths and Tui case, which you might have been thinking of, is actually, I think, in file 4.
Thank you. Mr. Shaw, Mr. Cook, could we sit at 10:15 tomorrow? Yes? Thank you very much.